speakers who have agreed to take part in this discussion, and to Dr. Sami, Director of the Judicial Academy, and his team for hosting this webinar and for continuing to provide distance training, notwithstanding the ongoing difficulties presented by the coronavirus pandemic. This is a pre-recorded webinar focusing on the effects of coronavirus on judicial policy. An insightful discussion will take place between 5 experts from around the world, namely the United Kingdom, the United States of America, and Abu Dhabi. I will now introduce you to our first speaker, Dr. Ahmed Abdulzahir. Dr. Ahmed has a law degree, a higher diploma in common law, and higher diploma in criminal sciences, all obtained from Cairo University. He also studied in France, obtaining a PhD in criminal law and human rights. He is currently a professor of criminal law at Cairo University and a legal advisor at Abu Dhabi Judicial Department. Thank you.
Thank you so much. I am delighted to be invited by Abu Dhabi Judicial Academy to participate in this webinar on judicial policies in response to coronavirus COVID-19 crisis. In the beginning, I would like to start by giving a few examples revealing the impact of coronavirus pandemic on prisons and criminal justice in general. In other expressions, how coronavirus affected prisons and the criminal justice worldwide. Some reports estimated that around 500,000 prisoners around the world were released due to coronavirus outbreak. On the other side, the United Nations urged governments to release older and more vulnerable inmates. In addition, on April 10, 2020, the Supreme Court of Washington directs the Governor and Secretary of the State of Washington Department of Corrections to immediately exercise their authorities to take all necessary steps to stay safe and protect safety and health of all departments of corrections inmates, and to report to the court in writing no later than noon April 13, 2020, all steps that have been taken and will be taken, and their emergency plan for implementation. If you need more examples, we can also mention that the British Justice Ministry urged to limit court hearings to most urgent. During my session, I will talk about the strategy of criminal justice in response to coronavirus crisis and to do a plan against this situation. I think first important to clarify the meaning of judicial policy or judicial strategy. The word policy or strategy refers to a code of practice or approach. In other words, an action plan designed to achieve a long-term aim, the art of planning and directing all military operations and movements in a war or a battle. Maybe you will find abnormal to refer to words like war, battle, military operations, but really we are now in a real war, a real battle against this virus, tackling all the world. And in this battle or war, everybody and each organization must take part to bring end to this situation. Related to judicial system, and if we mention the experience of Abu Dhabi Judicial Department, we can refer to several decisions. But without going into details, I think it is very important to mention only 2 decisions. The first one the administrative decision number 61 of 2020, adopting continuity procedures during coronavirus crisis. The second one is the administrative decision number 71 of 2020, concerning the formation of a committee entrusted with the production of an action plan for the return of court operation amid coronavirus crisis. Limiting my speech to criminal justice only and to build our action plan against coronavirus, I think reasonable to have two aims. The first one, how to reduce the number of persons attending in court hearings. In other words, how to reduce in-person hearings. The second aim is how to reduce the number of prisoners. As we have two aims, I will split my session into two sections or two parts. The first part is about how to reduce the number of persons attending in court hearings, how to reduce in-person hearings, and we can achieve this goal by several ways and by applying several provisions. Having in mind this goal, Article number 5 of the Administrative Decision number 61 of 2020 stipulates 5 provisions. First one, criminal orders system shall be activated and its scope of application shall be expanded to some crimes such as bounced check, in which the check value doesn't exceed 500,000 dirham. Second provisions is remote investigations shall be implemented using CCTV in all criminal cases. Third provision is video conference shall be used in all trials. Fourth provision, the accused party's attorney may meet with his client and attend with him the investigations or the trial procedures via video conference. Fifth provision is the accused is non-Arabic speaker. The court shall use an interpreter via a remote interpretation room. If we wanted to go to the second aim, how to reduce the number of prisoners, we can achieve this goal by several ways also, applying several provisions of the federal law related to criminal procedures number 35 of 1992. For example, we can apply the punishment of placement under electronic surveillance as a substitute of short-term detention. We can also urge the judges to choose fine instead of short-term detention. Finally, I think it is very useful if we refer to some phrases of Lord Chief Justice of England and Wales, who has made clear that court systems will never again operate as it did before the coronavirus pandemic struck. Thank you for listening, hoping that I respected my timing.
Thank you so much, Dr. Ahmed. We will now move on to our second speaker, Mr. Heyb F. Wilson. Heyb is an American arbitrator and legal counselor with more than 28 years' experience in the United Arab Emirates and neighboring countries. He has acted as a tribunal chairman, sole arbitrator and co-arbitrator in arbitration cases seated in the UAE. He serves as lead counsel for multinational corporate clients and has provided expert testimony in US courts on commercial disputes governed under the UAE, Saudi Arabian, and Egyptian legal systems. Thank you, Hib.
Thank you very much, Chloe, and thanks to the Abu Dhabi Judicial Academy for inviting me to participate in today's session. COVID-19 was like a tsunami crashing across the global economy. In a recent report published just a few days ago, the International Monetary Fund projected that the world economy will contract by 4.9% during 2020, and the IMF projected a 4.7% contraction for the economies of the Middle East region. Already, governments throughout the world have been forced to devote significant liquidity to public health measures to control the pandemic and to provide health care for both citizens and residents. The worldwide focus of government spending on health care and public health measures, coupled with the global economic slowdown, means that commercial businesses are likely to face very hard times in the coming months. Many commercial companies may find themselves trapped between the heavy weight of obligations to lenders, vendors, suppliers, landlords, and employees on the one hand, and obligations to clients and customers on the other. The United Arab Emirates will not be exempt from this phenomenon, and therefore contract disputes arising out of the COVID-19 crisis will inevitably find their way into the courts of the UAE as both individuals and companies seek relief from contractual obligations that no longer seem economically viable. UAE law provides four main avenues of relief for parties facing economic or financial distress. One of these, bankruptcy and insolvency law, will be familiar to an international audience, although it's a relative newcomer in the United Arab Emirates. My colleague, Judge Oren, will be speaking about bankruptcy and insolvency issues later on in this program. As for force majeure, in Arabic this is called al-quwa al-qahira, it is also well known internationally, although the doctrine of force majeure in UAE law is substantially different than lawyers and business people trained in the Anglo-American common law tradition may expect. The third doctrine, which is unique to legal systems in the Arab world, is called unforeseen circumstances, or sometimes exceptional circumstances. Codified in Article 249 of the UAE Civil Code, this doctrine shares some features with the French doctrine of imprévision, but the effects of the two doctrines are really quite different. Finally, the doctrine of excuse, codified in Article 794 of the Civil Code, may be relevant to certain types of contracts. In the UAE Civil Code, force majeure, exceptional circumstances, and excuse each provide a legal basis for an obligor to seek relief from its contractual obligations. Under UAE law, force majeure arises when an external factor outside of the obligor's control makes it impossible to perform the obligation. While some contracts define force majeure more broadly, in the absence of a contractual definition, the key element of force majeure under UAE law is impossibility. Many legal consultants mistakenly assume that the existence of force majeure temporarily excuses delays in performance while it is impossible, but that the contract itself remains valid and in effect, with the obligation resuming after the effects of the force majeure event end. And indeed, many English language contracts are drafted with this idea in mind. However, if Article 273 of the Civil Code applies to the contract, the existence of force majeure results in cancellation of the affected obligation. Depending on the nature of the relevant contract, this might happen automatically. In Arabic they say, انفسخ العقد من تلقاء نفسه, or the obligor would have the right to rescind the contract on notice to the obligee. The statute says in Arabic, يجوز لدى انفسخ العقد بشرط علم المدين. In contrast to force majeure, the doctrine of exceptional circumstances does not require that performance became impossible, nor does it lead to cancellation of the contract. Instead, Article 249 requires the existence of an unforeseen circumstance prevailing throughout a nation or community that makes performance of the contract unduly burdensome and threatens the obligor with grave losses. Article 249 authorizes a court to reach into the economic relationships set forth in the contract to adjust those mutual obligations to a more reasonable level so as to apportion the losses between the contracting parties in a fair and equitable manner. In the past, courts in the United Arab Emirates have been very reluctant to apply Article 249. Although my research identified a number of published cases where litigants sought to invoke Article 249, in every one of these cases, the courts ruled that the criteria for applying Article 249 had not been met. However, in analyzing Egyptian Civil Code Article 147, on which the UAE provision is based, Professor Sanhouri expressly mentions pandemic as one of the exceptional circumstances that could justify applying the doctrine. Judges in Abu Dhabi and Dubai should therefore anticipate encountering claims under Article 249 of the Civil Code and should prepare a strategy for addressing them. I'll take a moment to briefly mention Article 794 of the Civil Code, which provides that in a contract for hire, either party may terminate the contract if he is affected by an unforeseen excuse. In Arabic, عذر طارئ يتعلق به. A few points. First, Article 794 is derived from principles of Islamic law, and specifically the concept that a contracting party should not be forced to suffer harm, the risk of which he did not bargain for in the underlying contract. Second, while both Article 249 and 794 relate to unforeseen exceptional circumstances, Article 249 applies only if the circumstance is public in nature. In other words, if it affects an entire nation or community, or at least a category of people. The personal circumstances of the obligor are not relevant under Article 249, and the court should not take them into account. In contrast, Article 794 can be invoked by an obligor based on his own personal circumstances, for example, loss of a job. A 2018 decision of the Federal Supreme Court in a case arising from a lease of agricultural land in Fujairah illustrates this point. In that case, a tenant cited salary delays and farming losses that made him unable to pay the agreed-upon rent, and he had a successful claim to terminate the lease. Third, insofar as Article 794 is based on principles of Islamic law, it's worth noting that fiqh scholars use the term ijara, which we commonly translate as lease, to encompass a wide spectrum of contracts for hire, including leases over both real and chattel property, as well as contracts for personal services. If a court in Abu Dhabi is faced with a claim under any of these doctrines, it must first determine whether the Civil Code applies at all. In doing so, the first place to look is outside the Civil Code itself to UAE Federal Law Number 18 of 1993 concerning commercial transactions. Article 2 of the Commercial Code sets forth an order of priority for the rules governing commercial contracts. First, mandatory provisions of the Commercial Code. Second, the contract between the parties. Third, applicable provisions of other commercial laws, as well as non-mandatory provisions of the Commercial Code. Fourth, local and particular rules of commercial custom. Fifth, general rules of commercial custom. And in last place, number 6, provisions of the Civil Code that don't conflict with general principles of commercial activity. In theory, then, the specific terms of a private commercial agreement or the custom and practice of merchants could take priority over a Civil Code provision like Article 249. However, a court might decide to apply Article 249 anyway on the theory that it constitutes a rule of public order. It's worth noting that the text of Article 249 says that it cannot be excluded by contract. Assuming that 249 applies to a commercial contract, what exactly is the court's mandate? Courts faced with claims under Articles 273 or 794 have a fairly straightforward task. They decide if the circumstances constitute force majeure, in which case under Article 273 the obligation is canceled, or a valid excuse, in which case under Article 794 the party affected by the excuse can terminate the contract. In contrast, a court facing a claim under Article 249 must first decide if the facts support a claim of exceptional circumstances. Then, if they do, then their hard work is just beginning. The court must now decide how to adjust the obligation in a way that fairly and equitably apportions the losses between obligor and obligee. This will likely require the court to consider a report from a subject matter expert who can assist the court in identifying and quantifying the losses, determining what portion of those losses was foreseeable, in other words, losses that constitute normal business risk for which the obligor is responsible, and separating that portion from those losses that were unforeseeable and which fairness requires must be shared between the obligor and the obligee. The court itself, which is the ultimate expert and which has both the capability and, under Article 249, the obligation to consider questions of fairness, justice, and equity, factors which are far outside the scope of an expert's mandate, must then decide the best way to apportion those losses between the two parties. The nature of this task is such that it will inevitably leave both parties unhappy. Over and above this, it is important to recognize that Article 249 is aimed at protecting the obligor from crushing losses arising from forces outside his control, and is also intended to preserve the validity and effectiveness of the contract. Accordingly, the court will be under pressure to complete its analysis and apportionment quickly, so as to provide timely relief for the obligor and certainty to the parties. If the court's decision is unduly delayed, the crushing nature of the obligation might force the obligor into bankruptcy or liquidation, thus defeating the purpose of Article 249. Thank you very much for this opportunity.
Thank you very much, Hip. Our next speaker is Judge Benjamin Bürger. Benjamin qualified as a barrister in 1995. He is now an employment judge based in London, England. Between 2017 and 2019, he was employed as a legal consultant, advising ADJD on the development of law and practice in labour law and litigation processes. He regularly provides training to judges and lawyers and has presented in the United Nations in Geneva on UAE labour law. Thank you.
Thank you very much for that introduction, Chloe. And thank you, Dr. Sami, for setting up this webinar and giving me the opportunity to give the little insight that I can from a labour law perspective. There are three aspects of my presentation that I'll be addressing. The first is, what effect does COVID-19 have on the employment relationship in contract terms? I'll then move on to discussing how the courts protect employee rights in the COVID-19 context. And then I'll conclude by looking at whether litigation and court processes are in effect the right solution for dealing with a COVID-19 pandemic. If I start then with the first matter, which is what effect does COVID-19 have on the employment relationship? We all know that the employment relationship is binary. The employer provides the work and agrees to pay. The employee agrees to provide services for that work. When there's a pandemic, there's an issue as to whether the employer has work to provide. Is that a medium term? Is it long term? Is it a final aspect? Does that then undermine the contract itself? And what effect does it have on the contract? There are a number of aspects you can look at. If the contract no longer is able to be completed, does that mean as it's frustrated, or does it mean that force majeure means it can no longer be relied on? We know that the contract term must be looked at the starting point. However, we know also all contracts have implied terms. Implied terms to provide a safe system of work. And if an employer wishes to continue regardless in relation to a COVID-19 pandemic, question is whether it is protecting its employees or exposing them to unnecessary risks. Obviously, the pregnant women, elderly, and those with pre-existing health conditions, if their employees have a significant argument to say, if you're expected to come to work in these circumstances, you are not providing a safe system of work. If you're not providing the appropriate equipment, the PPE equipment, then also you're not providing a safe system of work. So the employer has to take responsibility, whether it's looking at the contract as to whether it can provide work, or whether it's looking at the circumstances in respect of the equipment and environment that the work is allowed to be undertaken. And long and short of it is, there is no one size fits all. Different environment, different structures and different industries will have different pressures that are created by the COVID-19 pandemic. If I move on to the second aspect, which is how do the courts protect employee rights in the COVID-19 pandemic? We know that travel to court and access to court has been severely limited due to the fear of contracting the virus. So getting to court physically has become a hurdle. And if you can't get to court to present your claim, then your accessibility to court is curtailed. And that has an access to justice issue. If you also have a limitation of access to your lawyers, you cannot get specific information, advice, and strategy about how to proceed with your claims. So the extent to which employees and employers in certain circumstances have the ability to use the courts can be severely restricted in the COVID-19 pandemic. The solutions have been, and we can see this already in the UAE, with allowing remote access, having online courts, having access to telephone registrations, or having the courts go to labour camps with buses. They're all innovative ways. But if you're relying on the remote access, you've got to also be aware that there are very vulnerable workers who do not have the funds to have data to get online. They don't have the broadband to be able to get online. And sometimes they may not even have the literacy to do so. So that's why they need to have the lawyers to do that. And these vulnerable workers should not be overlooked by implementing the IT innovations that are being rolled across around the world. We know also with Abu Dhabi in particular that they've introduced a summary matters court, which is to prevent employees being evicted for work-related matters or in relation to their contract. This is effectively expanding the court's jurisdiction to deal with the difficult circumstances. Finally, if I look at the whether litigation and court processes are the right solution for COVID-19 pandemics, my initial and definitive conclusion to this is no. There needs to be, in these exceptional circumstances, legislation, regulation, and directives that are dealing with the exceptional circumstances. Employees and employers had not anticipated the nature and extent of the shutdown to their livelihood or their ability to provide a business. And we know in the UK, the Coronavirus Act provided support for employers to ensure that businesses were able to be supported during the difficult time by actually paying by the government to employees their salaries. We also know that the legislation in the UAE, with I think it's Directive 279 of 20 and 280 of 20, provides guidance at which employers have to follow in respect of allowing annual leave, protecting health and safety, and ensuring that employers have the cash flow with the wage protection systems. So government has a significant responsibility to step in and regulate the relationship during this time, because employees and the employment contract relationships simply hadn't anticipated that. So they're the three aspects that I've discussed, and hopefully we can discuss further matters of that in the question and answer session later. Thank you.
Thank you very much, Benjamin. So our fourth speaker is Nafeen who has over 20 years legal experience and is a barrister from London. He has been with the Judicial Department since 2017 as a legal consultant, specialising in real estate matters. As a member of the International Experts Chamber in the Commercial Court, Nafeen draws on his skills and knowledge as an adjudicator, arbitrator, and conciliator. Nafeen is an honorary fellow of the University of Southampton and a trainer with the Inns of Court College of Advocacy in England. Thank you.
Thank you very much, Chloe. Thank you to the Academy for allowing me this opportunity to take part. I'm going to focus on the effects of COVID-19 on real estate disputes, the focus being on Abu Dhabi and the UAE, and I'll mention very briefly what's going on in England. So the Abu Dhabi government, under its Gadan 21, launched 16 initiatives. This is the Tomorrow 21 package to promote economic stimulus in the Emirate. And with COVID-19, they've had to make adjustments. And until the end of this year, there's essentially no charge of individual or commercial real estate registration fees. In addition to that, there's no Tawfiq fees for commercial and industrial activities. There's also been a 25% reduction in industrial land leasing for any new contracts. And there's also up to a 20% rebate on rentals for the restaurant, tourism, and entertainment sectors. This is all to support businesses during this difficult period. As far as the Judicial Department is concerned, there's been a stay on all existing rental property eviction cases, together with any enforcement action, such as the freezing of bank accounts, seizing of vehicles, stocks and assets, etc. That was initially until the 15th of May, but has been extended until further guidance is issued. I mentioned the 20% rebate. The Department of Economic Development actually launched its own digital service so that those from the restaurant and tourism sector can go straight online to apply for that 20% refund. And that will take effect for any leases which started from September last year or were renewed in April this year. And it also applies to cases of rent with a fixed rent or turnover rent. If you've got a lease which provides for both, it applies to the fixed rent part only. So we've had mention of the civil code, and we're looking at disputes that are coming to the courts. It's been made clear that a party can rely on potentially the effects of COVID-19 to say that the contract is impossible to perform and therefore seek to terminate it. But it's going to be, the onus is on the party to actually demonstrate that it's either going to be the impossibility test is a high threshold. So the starting point always should be, what does the contract say? And in the real estate situation, it's usually the lease. And there's also got to be some consideration of any notice provisions. So when the courts approach these cases and they're looking at the lease, if a party seeks to rely on force majeure, is that actually provided for within the contract? Even if there is some reference, what we've got to look at is the circumstances of the case. Is there total impossibility, or is the possibility only partial? And the court's going to have to take each on a case-by-case basis. We've got to be, conscious of the fact that the Civil Code 1985 law doesn't actually make clear what is a force majeure event, and it's understood that it's largely limited to unforeseeable events. But I think there's far more merit, and as Herb's alluded to already, in Article 249, and that's where I think the balancing act is going to take place, and in particular from tenants, those cases that come before the court, because there's reference to the public nature part, and we also had government decisions issued. following the lockdown, I think that's where there's the opportunity for parties, given the circumstances of their case, to actually come to the court and seek the court's discretion, so that those onerous elements contained within a contract can be adjusted to make things fairer. We've also got to, in terms of the cases that come to the court, I think we have to be very careful that it's not an opportunity to essentially renegotiate or recover losses. The court's going to have to look very, very carefully into the circumstances, because when it rebalances or adjusts, it's got to look at how it impacts on the the innocent party, and any obligations that are to be altered. In addition, I think it's relevant to also look at Article 287 of the 1985 law, because what this refers to when we're looking at damages, for example, is that if a loss arises out of an extraneous event in which a party played no part, and that would include force majeure, then it won't be required to remedy the loss in the absence of an agreement specifying that. So therefore, the default position under the law is that when delay or non-performance is caused by circumstances or events beyond the control of the party, it's not obliged to compensate the other for losses suffered as a result. Now, one of the other things I think, especially with construction cases, is with Article 390, which has subsection 1 and subsection 2. Subsection 1 recognises that parties can and are free to fix the amount of compensation payable, and that will be specified in the contract. But 392 goes on to say that even if that's the case, it's still open upon application by one of the parties for a judge to vary that, so that the compensation and level of loss can be adjusted, and that could go up or down. So I think that's going to be quite interesting, and it's interplay with construction cases. Sadly, we've seen with the pandemic, people losing their jobs, there have been layoffs, and there's been some pressure on landlords to waive rents. Whilst we've seen in the commercial sector and retail space, the likes of Amar, Aldar, Mubadala, they've taken the lead and announced rent reliefs. That's not necessarily the case within the residential sector. There's been a well-publicized decision coming out of Dubai where force majeure has been quoted, but I think it's not very well stated in the media, but it's not as straightforward for a party to say, I've lost my job, force majeure applies, and try to walk away from its tenancy obligations. So within that residential space, I think there's going to have to be it's going to be difficult for tenants to say, especially when they've been asked to stay within their homes during the lockdown, they're confined to that space, so it follows that rent is due. Having said that, some property managers and the larger landlords have given some deferment in rent payments that are due, but each case will be treated on its own merits depending on whether individuals have lost their jobs and their ability to pay. So if I just going back to how over the next few months we'll see landlords potentially trying to work much more closely with their tenants. I don't think we'll see a rewriting of contracts, but there may be, for example, additional checks being allowed to be issued to cover rents, and also working with them, keeping in mind that they don't want to lose a tenant and have an empty unit. It's better for it to be occupied. With construction cases, most of the time, a well-drafted force majeure clause should prescribe exactly what the notice requirements are, mitigation requirements, and any remedies that would apply should such an event occur. So with COVID-19, you know, what does someone do who wants to rely on this, where either a project's been put on hold, they've lost workers, or materials have been quarantined? And again, we've got to go back and see exactly what the contract says, because there's going to be implications for the contractor and the employer. And it's also important to get the distinction right between force majeure and urgent circumstances. That force majeure is where the work's impossible to perform due to a cause beyond control of either party, whereas urgent circumstances is where that performance becomes more difficult, and in which case the courts might be persuaded to reduce any overly onerous obligations, so that margins are reduced to a more reasonable level, or possibly compensation being awarded. Benjamin's talked about safety for workers who are asked to return, and equally within that commercial real estate space, as businesses reopen, as malls get occupied, what are the steps that tenants, landlords and tenants should be taking? Well, safety of the workplace for their staff, and landlords need to ensure that the common parts of the buildings are safe for occupiers. So we're looking at risk assessments being undertaken, and there are directives from local government, municipality in respect of that. But who's going to pay for this? There's going to be an additional cost, and the landlord, if it's providing additional services such as deep cleaning, hand sanitizer stations, screens, or temperature screening, you know, these additional costs are going to be passed on to tenants, probably through their service charge. So there may be some contention around that. And where their service charges have already been capped, then yes, the tenant's protected. But I think we may see some cases where there's a question mark whether certain measures were taken which were proper for managing the building, or whether they've gone beyond that. Also, there's got to be some clarification around what tenants can do, where as much space is potentially not required. There may be a request to reconfigure that space. Some tenancy agreements allow for that, there's no issue, partitioning, etc. But where it goes beyond that, I think landlords are going to be sensitive to this. So the appropriate consents need to be obtained, and that may include, again, approaching the municipality to get those approvals. So with these challenges that have been presented with the pandemic, I think it's what it's shown is the great steps that were taken in the past couple of years through the public sector with the digitization of services and moving over to online platforms. So within the property transaction sphere, you know, there was a concern, how are we going to buy and sell land or property, or how are we going to sign up new tenants? Now, fortunately, ADJD with its notarization services, and also the municipality, they have allowed for electronic signatures in appropriate circumstances, as opposed to a traditional wet-in signature. So as long as you can authenticate the document and all the relevant formalities relating to the execution of the document are satisfied, then those types of signatures will be accepted. There's going to be verification of identity and so forth, all within that. So as I wrap up then, I'm just going to mention in England, the government last week introduced a voluntary code of practice for commercial property relationships. And the emphasis was on collaboration, transparency, stakeholders having a unified approach, recognizing the government support that's been provided financially, and to identify mutual solutions. I mention all of that because the aim should be for parties, if they can, to try and resolve their disputes before coming to court. And fortunately, only this month, His Highness approved the first batch of real estate conciliators at the Dispute Settlement Centre at the municipality under the SWAYA. And I would hope that there will be a good uptake in the service provided by those accredited facilitators, conciliators, so that those disputes can be resolved amicably, and they are supported by the court because they'll be endorsed and stamped and enforceable. Thank you very much.
Thank you, Naveen. So now I'd like to give a warm welcome to our final speaker, the Honourable Oran F. Whiting, a 12-year Illinois State Court judicial veteran. He was appointed as a judge by the Illinois Supreme Court after a successful 32-year international law firm legal career. He served as a law professor since 2018 and has been employed by ADJD as a court of first instance judge, legal consultant, and judicial trainer since 2019. Thank you. Oran, if you could just take your mute button off and start again, that would be great.
I'm sorry. Thank you, Chloe, for the opportunity to speak, and the Academy and Dr. Sami. I very much appreciate it. Today, I will be explaining and comparing how COVID is affecting policy in the US and in the UAE's bankruptcy courts. The two countries have taken similar approaches in confronting the challenges posed by the virus. However, the USA has actually directly changed its laws, while the UAE has not. Let's begin with the United States. In response to the COVID pandemic, the US President signed into law the Coronavirus Aid, Relief, and Economic Securities Act, otherwise known as the CARES Act, to provide a $2 trillion economic stimulus package to support US businesses and individuals impacted by COVID. The CARES Act also includes revisions to certain provisions of the US Bankruptcy Code in an effort to provide better and more effective bankruptcy relief to small businesses and to individuals. The CARES Act amends the Small Business Reorganization Act of 2019, SABRA, which became effective in February of 2020 to temporarily increase the debt threshold for filing for relief under the new subchapter 5 of chapter 11 of the US Bankruptcy Code from $2.7 million of debt to $7.5 million of debt. The Small Business Reorganization Act is designed to enable small business debtors to reorganize their financial affairs in a more efficient and cost-effective manner, while also maintaining more control over their businesses. Historically, Chapter 11 reorganization has not been a viable option for most financially struggling small businesses due to the length and unmanageable expense of the process. Some of the other key features of the Small Business Reorganization Act are Subchapter 5 debtors are not obligated to pay quarterly U.S. trustee fees, which in traditional cases can be significant. Creditors' committees will generally not be appointed. This will help to minimize the chances of disputes and distractions in a Subchapter 5 debtor case, and which the debtor may face in a Chapter 11 case. A standing trustee will be appointed in every SABRA case. The trustee's supervisory role will include helping the debtor formulate a plan, reporting fraud or misconduct, and monitoring distributions under the plan. Only the debtor is permitted to file a plan of reorganization, which eliminates the risk of completing plans being filed by creditors. A disclosure statement is not required unless the court orders otherwise. Also, unlike in a typical Chapter 11 debtor, in the new cases, a small business debtor may stretch out the payments of administrative expense claims over the term of the plan. The Act also amends certain provisions under Chapters 7 and 13 of the U.S. Bankruptcy Code to help individuals or consumers who will or have been financially harmed by the COVID pandemic. The key changes that consumers should be aware of are that Chapter 13 debtors with existing confirmed plans who have suffered material financial hardship due to the pandemic will be allowed to seek plan modifications, including extending their payments for up to 7 years after their first payment plan was due, thereby reducing their monthly payment obligation. Also, coronavirus-related payments received by families and individuals from the federal government as a result of the acts and other stimuli will not be included in the definition of income for eligibility purposes, and also will not, such payments will not be included in the calculation of disposable income for plan confirmation purpose. This change is designed to permit consumer debtors to receive the full benefits of consumer stimulus packages. The federal bankruptcy courts in the US have modified their operations to help protect public safety and are implementing measures to facilitate the administration of cases by using electronic means to conduct hearings and meetings, submit evidence, examine witnesses, and to generally administer cases. Samples of how certain jurisdictions are handling cases include the Southern District of Texas, which is tolling all court-imposed deadlines. Delaware, Southern District of New York, South Dakota, and Texas are conducting hearings telephonically and have created protocols for submitting evidence. The same states have suspended the requirement to obtain original signatures on bankruptcy documents. Texas is also allowing judges other than the judge assigned to the case to preside over hearings. Certain courts have completely suspended bankruptcy cases under the court's equitable powers under 11 USC 305A. In general, governments in the US are temporarily tilting their bankruptcy laws in favor of debtors to help businesses survive the crisis. Some have taken advantage of the crisis to propose permanent pro-debtor bankruptcy reforms. Let's move on to the UAE. The UAE has taken a number of rapid, significant actions at government and banking levels to support businesses and individuals suffering financially from the impact of the pandemic. It's also adopted various social distancing and lockdown protocols in its courts in order to contain the spread of the virus itself. As part of the government's preventative measures to limit the consequences of the virus, the UAE federal cabinet established a committee to address the impacts of the virus on the national economy. In March of 2020, the UAE Central Bank announced a targeted economic support scheme comprising of a 100 billion AED stimulus package with a further pledge of 16 billion AED to help with business activity, all of which became effective mid-March of 2020. The Abu Dhabi Executive Council announced an accelerated 3-year stimulus package in mid-March to support the private sector, residents, and startup companies. The aim of the accelerated initiative, which has been fast-tracked to meet the challenges raised by the COVID situation, is to offer relief to small and medium enterprises and loans to local companies. The initiatives include 5 billion AED to subsidize water and electricity fees for startups, exempting all commercial and industrial activities from real estate registration fees until the end of 2020, and 1 billion AED to establish a market maker fund that enhances the liquidity and sustains a balance between supply and demand for stocks. Further examples of adjustments made specifically in Abu Dhabi include the Abu Dhabi Commercial Bank offering to defer loan installments and to waive interest for up to 6 months for individuals or business owners subject to approval, reduction of industrial land leasing fees by 25% on new contracts, waiver of certain commercial and industrial penalties, suspension of tourism and municipality fees for tourism and the entertainment sectors until the end of 2020, exemption for commercial vehicles from annual registration fees until the end of 2020, and exemption of all vehicles from road toll tariffs until the end of 2020. As of April 5th of 2020, the UAE doubled the size of its initial stimulus to 256 billion AED, and it's allowed banks and finance companies in the country to extend deferrals of principal and interest payments to their customers until the end of the year, December 31st, 2020. Unlike the US, there has been no adjustment to the UAE's bankruptcy code itself. Companies in the UAE, except for those incorporated in the Dubai International Financial Center or the Abu Dhabi Global Market, are subject to federal bankruptcy law, Federal Law number 9 of 2016, which regulates insolvency. Courts and arbitration centers in the UAE have taken swift action to ensure the continued health of key stakeholders without foregoing their responsibility to the people they serve. The use of technology to mitigate as best as possible the impact of the global pandemic on the business community has been a strategic part of each forum's response to COVID's restrictions, and courts have remained operational using these means to conduct hearings and meetings, submit evidence, examine witnesses, and generally administer cases. On March 23, 2020, by order of His Highness Sheikh Mohammed bin Zayed, the Abu Dhabi Judicial Department suspended all rental property eviction cases and execution procedures related to civil and commercial cases, including the blocking of bank accounts and the attachments of assets. The parties do not even have to request this relief. The suspension, however, does exclude cases related to alimony and employment disputes. Hearings in all cases not set for final judgment were suspended for not less than 30 days, whereas those matters previously scheduled for hearings within 30 days were rescheduled and assigned new hearing dates. In event of cases already reserved for judgments, the courts continued to render judgments even in the absence of the parties. On March 30th, 2020, the Abu Dhabi courts issued administrative decision number 61 for the year 2020, which provided that all court proceedings, court hearings, and notary public ratifications be done through electronic means through the Abu Dhabi court electronic system. Certain aspects of bankruptcy law requiring more physical, hands-on administration, including asset liquidation, have been delayed, if not suspended entirely. In general, the UAE is implementing measures to favor debtors to help businesses survive the crisis. Thank you very much for the opportunity to speak.
Thank you, Oren. So thank you all for such great overviews of the impact of coronavirus on judicial policy. And I can certainly speak on behalf of myself that I've learned a lot from all of your speeches. We will now move on to the question and answers. So the first question is, what assistance can be provided to legal professionals and litigants who lack resources? Now, if we can start with Dr. Ahmed.
Thank you for this very important question. For sure, we live now in an unexpected situation. We can use also the terms of the expression of extraordinary circumstances to describe our situation now. If you asked before 2020, if you asked anybody about his expectation of 2020, for sure nobody can expect what happen now. For sure we must deal with this situation, but our reaction must be moderate. We have to take in consideration the circumstances of some people. That's why the article number 4 of the administrative decision number 62 of 2020 stipulates that in order to maintain the rights of the litigants, even if they fail to attend the session remotely, no case shall be dismissed, taking into account the current circumstances. Not only that, but Abu Dhabi Judicial Department, taking into consideration the circumstances of employees, established a remote hearings room in ICAD city to allow employees to go to this room and can communicate with the court online. This is the reaction of Abu Dhabi Judicial Department, and we can see very well that this reaction take in consideration the circumstances of some people.
Thank you, Dr. Ahmed. Benjamin, is your experience any different in the UK?
No, I think I agree with a lot of what Dr. Ahmed said there. You've got to take into account the circumstances of the individuals and also be very aware of the need to ensure there was litigation that can continue to provide the rights and expose the liabilities of organizations in the difficult circumstances. So remote hearings, online access, telephone hearings, they're all necessary, but to be effective, as has happened in the UK, there had to be changes to the court processes, albeit limited, such as the time limits generally needed to bring your claim or to serve documents or to progress matters. It goes without saying that if someone is locked down, they're not able to give instructions, they're not able to find the documents necessary to prove their case. And so it's necessary to allow for those exceptional circumstances to be amended. And the civil procedure rules have done that, especially in the civil context. In the employment context, there's been presidential guidance, which completely changes the landscape of tribunal hearings. The starting point is they will all be remotely. We're slowly unwrapping that now because of the easing or the relative easing of the pandemic. So there's now hybrid hearings where we'll maybe hear the witnesses in person at tribunal, and then we'll have submissions or early arguments remotely through counsel. So we're mitigating or reducing the risk of potential exposure. But yeah, you have to take account of the relative circumstances. You have to do justice to the case. And that means in certain circumstances, you need to change what your previous expectations were. Most important, I think, though, is with all these changes, you need to communicate. There needs to be a very clear way of communicating what's going on. And that's by way of updates, regular updates on the website. For those who haven't got access, it's making sure that there is access to law centres or local free legal advice organisations. It may well be opening up libraries or local public buildings for use as annex courts to ensure that people don't have to travel and get public transport. But we just need to deal with the difficult circumstances. We're having in mind the need to ensure justice for the cases that are before them.
Thank you very much, Benjamin. Thank you. So the next question is, are remote deliberations efficient and as effective in producing quality judgments? So I'll first go to Naveen.
Thank you, Chloe. When we say remote, what are we referring to? Is it telephone, video? With judges and deliberation, especially if you've got, say, a panel of 3, it's quite common to sit together, set aside time, and run through the issues. But I suppose the challenge that's presented with the pandemic is you are wholly reliant on the telephone or video. So what can you do to maximize on that communication that's going to take place? Because really, when we talk about justice, each member of that panel needs to be understood, needs to be involved. Otherwise, we're not really giving due credit and approaching the exercise in a proper way. So there is that slight challenge, but I think you can overcome that as long as you're aware of minimizing background noise or disturbance. And if you have the opportunity to have a video call, sometimes you get your visual cues as well. So in answering the question, I think yes, they can be as efficient and effective. On occasion, you think of something and you'd like to just walk into your colleague's room and bounce it off them, but you can't. So they may be busy and you've got to schedule in that call and make sure that you deal with it then. So it's just about organizing yourself, I suppose, a bit better.
Thank you. So I guess in terms of when we're saying remote deliberations, we're referring to you potentially having a Microsoft Teams meeting or a Zoom meeting, or whatever remote technology that you're using. So Oran, I'm guessing that regardless of whether it's a deliberation or whether it's just a meeting, you experience the same problems, and as time goes on, does it get easier?
Well, I will echo the comments of my colleague and also my judicial buddy there. And I will also say that I am, first of all, incredibly impressed by the level of technology that exists with ADJD. which has made it much easier to partake in deliberations. I am a face-to-face kind of person in the sense that I think it's better to be in the same room as your colleagues. But because of the technology and the facial expressions and the ability to actually converse, I certainly think the technology has made it very possible for us to administer justice appropriately, and therefore the deliberations work wonderfully.
So if the deliberation was just through audio means, not audio visual, do you think it would be more difficult?
I think it would be more difficult if it was just audio. The visual aspect of things, especially when you're discussing facts and you're discussing the application of law to the facts, you really need to have that facial recognition and the emotion that comes in. I know certain of my colleagues, I won't mention Dr. Ahmed, but Dr. Ahmed believes that that's not as important, but he and I will continue to disagree on that.
Okay, thank you. So the next question is, if an employer has suffered business losses due to closures during the coronavirus lockdown, or because contracts have been cancelled as a result of the pandemic, and the employer wishes to downsize its workforce through layoffs or redundancies, can that employer rely on force majeure or exceptional circumstances to avoid liability to pay compensation for abusive termination or other benefits under contracts governed by the UAE federal labour law? Now, if we could start with Benjamin.
Thanks, Chloe. I think there are two aspects here. There's one, what an employer can do going forward in relation to the difficult circumstances that have been created by the pandemic. And the second is what happens to the current and outstanding liabilities. Now, in relation to the first bit, of course, if there's no future work, an employer can properly cite that as a reason for ending the contract and provide contractual notice and benefits. In the ordinary course of events, that would happen and the employer would be liable to pay the outstanding matters. It becomes complicated now then as to whether you can rely on force majeure and frustration. The long and short of it in the UK is no. There may well be insolvency or implications that they can, as a matter of fact, not afford to pay it because there's no money in the pot. But as far as legal liability is concerned, the contract is the contract. And because it's no longer foreseeable, able to be implemented going forward, doesn't mean it was not able or was impossible at the time up until the pandemic comes into effect. That's completely different circumstances, you can imagine, with a commercial contract to, let's say, build a building which hasn't been built in the future. If there has been work that's been undertaken by those labourers up to the ending of the contract, that's due in the UK. Now, as far as the UAE law is concerned, the labour law provides the requirement for remuneration, requirement for payment, the periods in which payment is required. The Civil and Commercial Code does not countermand that. So if money was due at a particular time, at a particular month, under the labour contract, according to labour law, it'd be very difficult, I'm interested to see what Heyerb says about this, for an employer then to say, well, no, the frustration and force majeure means that they can no longer be liable to pay what has been worked up until. As I say, going forward, the contract can be at an end. You don't need frustration or force majeure for that. It's just cessation of work, and an employer can end the contract on that basis without relying on force majeure. Hope that's clear.
Thank you, Benjamin. Herb, do you have anything to add?
Yeah, I do. Thank you. In fact, I think it's really not so much a question of force majeure or frustration. Frustration is certainly an English law doctrine, and it's not really applicable in the UAE. But as Naveen said in his talk a little while ago, impossibility is a very high bar, and I think it's quite difficult to show impossibility. Whether we're talking about labor or even other sorts of contracts. But to me, the real issue isn't so much does an employer have to pay wages for work performed up to and including the last day that the employee worked because of lockdown or whatnot. The question is whether a decision to downsize will trigger a conclusion that the dismissal was abusive termination or arbitrary termination. And under the UAE labor law, it's quite clear that any dismissal that isn't related to reasons of the employee's own work is considered to be an abusive termination. And there has been precedent in the courts that arises out of the 2008-2009 financial crisis where company decisions to downsize their workforce in response to losing contracts have been considered to be arbitrary termination or abusive termination, I think is a better English translation of the phrase, which then triggers a statutory right of compensation of up to 3 months of total package, salary and allowances for the terminated employee. And I think that here is where a court might be looking at the overall circumstances of the pandemic and might be looking not so much at concepts of force majeure and impossibility, but in concepts of unforeseen circumstances or extraordinary circumstances, however you want to translate Article 249, and perhaps also at 794 of the Civil Code to say, right, the employee is certainly entitled to his salary. He's certainly entitled to his accrued and unpaid vacation. He's certainly entitled to his end of service. But in the circumstance, we are not going to find that this was an abusive termination. And so he's not going to get that compensatory damages for abusive termination that he might get under other circumstances.
Great, thank you. So the fourth question that we're going to address is, can a tenant invoke the doctrine of force majeure or exceptional circumstances to obtain a rent abatement or to avoid scheduled increases in rent for a long-term lease or to mitigate the effect of minimum gross sale clauses? Now, Naveen, if you could firstly address this.
Okay, well, the standard contractual position with regard to disruptions in commercial leases would be to state that where an event prevents premises from being used, the rent will abate, i.e. not accrue, or partially abate for the period that the event prevents or partially prevents use. However, it's important to look at the exact wording of the lease being considered, as there are considerable variations in these types of clauses. Some leases may state where the event continues for a period, commonly 6 months or more, either party may terminate the lease. So I think the key element is, before such a clause applies, is it because of whatever's being claimed that the use is prevented or otherwise? We've seen, for example, during the shutdown, a lot of restaurants were still able to offer a delivery service. So that didn't stop the prevention of using the premises themselves. And I alluded earlier to government directions having to be followed by both landlords in terms of shutting down large commercial premises and then the tenants that they've got inside. So in that situation, who's the regulated party? Who is the one that the obligation falls on? So where a tenant's looking to look at abatement, we'll look at the contract, but otherwise, I think, my view personally is it's going to be a high bar, as Herb put it, for force majeure. But 246, could provide some assistance where, there's pressure on a tenant, especially when we're looking at turnover turnover and rent being set according to that. So the factual matrix involved in a particular situation will need to be given proper consideration.
Okay, thank you very much. Herb, have you got a response to this question?
Yeah, I concur with pretty much everything that Naveen said, and I'd just like to add a couple of other thoughts. So, once again, as I said earlier, force majeure impossibility is an extremely high bar. And if you meet that bar, what you're essentially doing is achieving termination. You're not necessarily getting an abatement. So it's a high bar to reach, and it also may not be the outcome that either the tenant or the landlord wants. And the same is true, I think, with Article 794, of the Civil Code, which I think expressly applies to leasing arrangements. But once again, that will achieve termination. That will give either party the right to cancel or end the leasing relationship. So I think the real interesting analysis here is under 249, the exceptional circumstances or unforeseen circumstances doctrine. And here, it's a very unusual part of UAE law. Unlike much of the other provisions that we see, it is not a remedy that gives cancellation. It is not a remedy that gives rise to a right to claim damages. It's essentially an equitable remedy that allows one party to request intervention by the court, and the court would then go in, and equity is really a clear part of it, because the statute itself directs the court to weigh the interests of the two parties and then take action if justice so requires to apportion losses somehow between the parties, to readjust the contractual relationship. So what would that mean in terms of a rent? Of a tenancy? It might mean readjusting the amount of the rent. It might mean rescheduling the due dates for rental payments. It might mean lifting the effect of percentage rents based on gross sales or turnover or something to that effect. And really what that is going to take is the courts being assisted by not only by expert, but the right kind of expert. This is not something where an accounting expert is going to be able to look at the books and records and just put things into an Excel spreadsheet and do a calculation. It's really going to take a very sort of sensitive type of expertise, looking at valuations, looking at economic activity, and then it's going to take a lot of the judge's own training and discretion and the values that the judge is bringing to the case to be able to find a way to apportion those losses between the parties. Because 249 is really about preserving the contractual relationship while at the same time cushioning the parties from the crushing blow of an unforeseen public event, such as, I think, COVID-19.
Thank you. That's really interesting. So now we will move on to the final question. Will the principle of open justice become secondary to the need for efficiency of court hearings? Dr. Ahmed? If you could just unmute, please, Dr. Ahmed.
Open justice is a principle of all court hearings. I was invited by Moroccan University to speak about open justice during coronavirus crisis. I think that we have to respect this principle, and we can get benefits from new technology to assure open justice and to allow everybody to watch and follow court hearings online. I think it is very important to recording court hearings and to allow everybody to have access to court hearings. It is not necessary that you allow them to go to the court hearing, but it is enough for them to go online and know about what happened in the court.
And Oran, would you like to add to that? Oran, please unmute.
Whoops,
thank you.
I'm sorry, I keep getting muted and unmuted. I know, I was going to say I agree. I agree with what the doctor said, and my comments really kind of follow my response to the other question that you asked me about remote deliberations. Look, again, I am a face-to-face kind of person. I would rather have in-person deliberations. I'd rather have in-person hearings or what have you. But again, with the correct technology and with the adjustments that have been made, I think there's certainly no let-off in the administration of justice and the decisions that have been made. So I agree.
Okay, so we have now reached the conclusion of the webinar. I'm sure that we can all agree that it has been very interesting. So again, a big thank you to our speakers. We hope that you all stay safe and well, and thank you for listening.
Thank you very much to the Abu Dhabi Judicial Academy and for Dr. Sami for organizing this, and for my colleagues and friends for participating in this. I think it's been a great session, and I really am honored and privileged to have been a part of it. Thank you so much.
Thank you all.
Thank you.
Thank you so much.
Thank you very much.
And thank you so much, Dr. Sami, for organizing this event. Thank you for all speakers. I was honored to participate with you in this event. Thank you.
Thank you.